so much, and thanks to LexTalk World Global Hybrid Conference 2022 at Dubai. And thank you for inviting me. My time is short. I have 7 minutes, and I'll try to wrap up on the topic India in the international realm of arbitration. As we are all aware that today arbitration is in India is governed by the Arbitration and Conciliation Act 1996. It has made great strides in formalizing and consolidating the provisions of the earlier statutes, like the India Arbitration Act of 1899, the Arbitration Protocol and Convention Act 1937, and the Arbitration Act of 1940. The Act derives its authority from the UN Cetral model law and is in line with India's international obligation to provide a formal mechanism of quick, alternate dispute resolution. The Act elaborately covers the procedure for domestic as well as international arbitration, right from the inception of appointing the arbitrator in Section 11 to the finality of the enforcement of the award in Section 36. Further, the Act specifically provides for enforcement of foreign awards under the New York Convention and Geneva Convention under Part 2 of the Act, provided that they survive any challenges under Section 48 of the Act, making the resolution of international disputes smoother. India has made substantial stands and substantial efforts to recognize the special arbitration requirements of certain sectors. The state of Gujarat, being a hub of international maritime traffic in India, has the Gujarat International Maritime Arbitration Center, which has been set up for exclusive focus on maritime and shipping sector disputes. PMAC is being established by the Gujarat Maritime University in collaboration with the International Financial Services Centers Authority in Gandhinagar's Gujarat International Finance Tech City. The Arbitration Center will help in greatly enhancing India's capability and potential to resolve international maritime disputes. India has consistently hosted and participated in international arbitration conferences as well as international arbitration activities, serving as a melting pot of ideas, opinions, vision, and the possibilities to bring further Indian arbitration law in line with international law. In fact, Justice N.V. Ramana, the Honorable Chief Justice of India, was a few days back in Dubai, where he inaugurated the International Conference on Arbitration in the Era of Globalization, the fourth edition. While all this being said, there is still a lot of distance to be covered by India as far as international arbitration stage is concerned. For example, in the year 2015, of the arbitrators appointed by Singapore International Arbitration Center, only 3%, and I repeat, only 3% were Indians. And the London Court of International Arbitration did not appoint any Indian as an arbitrator. India undoubtedly has been moving forward in the right direction with respect to the international realm of arbitration. Its active efforts to establish specialized arbitration centers is an acknowledgement of the ever-evolving nature of international commercial disputes. The Supreme Court of India has also played a crucial role in evolving the law of international arbitration in India. I'd like to give a specific example in this regard. The Apex Court, the Honorable Supreme Court of India, in its recent judgment of Amazon.com NV Investment Holdings LLC versus Future Retail Limited and others, has held that the emergency arbitration award passed by the emergency arbitrator under the SIAC rules is an award as per Section 17(1) of the Act and can be enforced by Indian courts under Section 17(2) of the Act. I'd like to also mention that the Indian Council of Arbitration has also signed up international agreements with about 40 major arbitral centers around the world. India is also a signatory to the New York Convention, and some of the major international cooperations that have been signed by the Indian Council of Arbitration will go a long way in terms of supporting the realm of international realm of arbitration for India. In closing, I would like to thank all of you for giving me this opportunity to speak about India in the international realm of arbitration. Being a parliamentarian, let me also tell you that apart from arbitration, the Indian government is also working very closely, and right now the parliament is seized with the draft bill of the mediation. So mediation is also going to come in a big way, and this, as a parliamentarian, I wanted to tell you because I'm also a member of this Parliamentary Standing Committee on Law and Justice. And the Parliamentary Committee of Law and Justice has also been meeting and taking views in terms of the draft bill on mediation. So therefore, this shows the commitment that India has to arbitration and mediation. This also shows, just to go, that the Indian Parliament and the Indian lawmakers at the highest level of authority of legislative power are seized with the idea of how we can strengthen arbitration, how we can take Indian arbitration to the international realm, and how India can become a cornerstone, a foundation, a hub of where international arbitration and the linkages and the seamless connectivity with international arbitration around the world can be ensured. My time is up. I have till 4:20. Thank you so much for this opportunity, and I wish the LexTalk World Global Hybrid Conference 2020 the very best and many best wishes going forward. Thank you. Namaskar.